All right. Hello, everyone. Good afternoon or good morning, depending on where you are based. It's 12:01 p.m. Eastern or 9 a.m. Pacific, and we are ready to get started with our brief. My name is Michael Loban, and I'm joined by my colleague Lucas Longo, and today we're going to chat about respecting user privacy in the United States, or more specifically in California. Now, the point of today's maybe a webinar or a brief is for us to have a conversation about what was announced just a week ago, to learn a little bit more about CCPA, to learn about company that got fined and what happened, and to see what are some of the lessons learned and the things that you and your organization should be mindful of. With that in mind, if you have any questions, please post them in chat, and we'll make sure to address them as we go through today's presentation. Additionally, we are going to do a live demonstration at the end of our discussion today. My name is Michael Loban. As I mentioned, I work at InfoTrust. I'm joined by my colleague Lucas Long, and InfoTrust is a global digital analytics consulting and technology company. And we're excited to chat with you today about this much needed and very relevant topic. With that in mind, one thing that I want to make sure that we get out of the way is today's discussion, our brief, should not be taken as a legal counsel. The information that we will cover is not intended to be a legal advice or counsel and is not represented as such. Action performed as a result of information provided are of you and your company's own choosing. Please obtain legal advice from legal counsel whenever taking action related to the law. With that, let's dive in. So what specifically are we talking about? On August 24th, 2022, first CCPA enforcement action was announced, and it was a $1.2 million settlement with the global beauty retailer Sephora. And here you can see the copy of the announcement made from Rob Bonta, the Attorney General. So in today's discussion, what we wanted to do is revisit what is actually CCPA and what it's supposed to represent, and what it means for organizations. Then we wanted to discuss specifically what was defined for, what was the violation, and then talk about, with that in mind, what do you need to confirm and check across your own organization to determine that something similar does not happen in your case or in your case. So those are the three things that we want and plan to discuss today. And again, if there are any questions that come to mind, please don't hesitate to post them in the chat. And if we're able to, we'll absolutely address them. So with that, let's talk about what actually happened and make sure that we have our data right. So first, before we talk about the case specifically, I think it's important for all of us to be on the same page about CCPA, California Consumer Privacy Act. I suspect it's not new to anyone who is on this call, and we've all heard the term before. It was passed in 2018 and became enforceable in 2020. And it grants privacy rights to California consumers and introduces requirements for businesses that businesses obviously need to follow. Specifically relevant for this discussion for today, disclosure and opt-out requirements related to the sale of personal information. So in a moment, we will dive into what we actually mean by the term sale of personal information as it applies to these regulations. And then in January 1st, 2023, new updates from the California Privacy Rights Act go into effect. And most notably, one of the things that goes into effect is the expansion of rights to include sharing of personal information. So again, two things that we really need to be mindful of is what does California Privacy Rights Act mean when it comes to sale of personal information and sharing of personal information, because the now understanding of those two definitions lies what actions we are going to be taking as marketing business leaders. So with that, Lucas, I will pass it over to you to talk and to define sale and sharing of personal data.
Thank you, Michael. One other thing just to kind of note here, we're really focused on the specific actions and the specific pieces that were cited in the settlement that were also kind of a part of a wider enforcement sweep from California. So various different notices that were sent out really industry-wide for violations of very specific items. And those are what we're focused on here today. There are obviously other requirements related to disclosures and things like that within CCPA beyond simply this whole sale piece. So keep that in mind. Just by checking off these different components doesn't mean that everything is good to go. It just means that some of the very visible aspects that have been focused on of late would be addressed. So important here for our understanding, thank you, Michael, for the context around the CCPA, is this definition of sale. I'm not going to read through that entire definition right there as it's written in the CCPA, but basically what it means is that any transfer of a user's personal information to a third party for some kind of business consideration falls within this rather broad definition of sale. Now, most notable in this initial judgment is the application of sale for an activity that many people kind of assumed, but some organizations pushed back on as being included within the sale definition. And that is for just using basically a third-party partner for advertising, for targeting, and even for the use of things like analytics when certain conditions are not being met, both contractually as well as with configurations. So in this particular case, it was found, and with the kind of the claim or the case that was brought against Sephora, it was specifically cited and found that the usage of third-party technology platforms and transferring users' personal information to those platforms for reporting purposes, as well as to enable targeting or advertising to those users via those different ad platforms. It's that activity that was found to be within that scope of the sale, thus triggering all of the additional requirements that we'll be talking about here today. So that's why the sale piece is so important. Most of you on the call today are probably doing some sort of activity or working with some sort of a platform across your digital properties that would constitute sale as defined here. Now, also important, Michael had mentioned that the Consumer Privacy Rights Act goes into effect here January 1 of 2023. And what that does is it updates the CCPA with some additional, kind of expands some of the scope, and then also more narrowly defines some of the activities. One of those things that is expanded is that consumers now have a right to opt out and have the right to be notified of not just the sale of personal information, but also the sharing of personal information. And specifically here, again, relevant for these advertising activities, is that sharing includes any transactions between a business and a third party for cross-context behavioral advertising for the benefit of a business, even when no money is exchanged. So it becomes even more clear that these types of just general advertising activities, any kind of like audience creation you're doing on your website to then target those users elsewhere. So things like retargeting, and even profiling of users, segmentation in order to then target those same users elsewhere would fall under these definitions. And so therefore puts you in scope of CCPA, and we need to make sure that the proper protections are in place, things like opt-outs and disclosures. One other kind of note. So we're really focused on California as it relates to this particular case and what we're talking about here today. California is obviously one state within the US. So it'd be remiss if we didn't also mention kind of broader US requirements, especially as we're talking about 2023, which I kind of refer to as the year of reckoning as it relates to privacy in the United States. because there are 4 additional states that have their own privacy regulations that go into effect throughout the year. So in the US, it is still a patchwork privacy approach. It is still state by state. There is a federal draft regulation that has made it all the way to the House. It's looking unlikely like it will be brought to the floor for a vote, but it has gotten further than any federal privacy legislation to date. And it's similar to a lot of the state regulations that have been passed to date. So just know that in 2023, there are also similar requirements related to opt-outs and to disclosures that relate to advertising activities for 5 states, not just California, and users' right to opt out of behavioral advertising and cross-domain targeting is a really core piece of all of those. So again, any kind of digital marketing, digital advertising activities likely to fall under those definitions. You need to make sure that you have the proper architectures and protections in place across websites.
Thank you, Lucas. So now with that in mind, one thing also just to re-emphasize, there is a reason we decided to revisit CCPA and specifically call out what is meant by sales of data and by sharing of data, because that helps us understand what is actually taking place and likely things that are going to become even more important in years to come when it comes to overall data privacy and data collection. But specifically, what did this mean for this specific case and the CCPA violation itself? So we distilled the CCPA violation in 4 different bullets. Number 1 is failure to disclose to consumers that they were selling consumers' personal information. So that's the first thing. Then failure to offer ability for those consumers, so those visitors to the website, to opt out of the sale activity. Then failure to process user requests to opt out of sale via user-enabled global privacy control signal, which we're going to revisit in a second. And then failure to cure a cited violation within the 30-day cure period currently available. And it's currently available. Lucas, when does it go away?
Oh, January 1st of 2023 for California. Yes. Super important there. The cure period basically provided for a notice could be provided. And then you would have 30 days in order to be able to rectify any of those violations that were cited. So there was a little bit of a grace period that was introduced with CCPA, just kind of full well knowing that, okay, there's 2 full years here. We want to give businesses a little bit of the benefit of the doubt, but that goes away January 1. So in theory, if a violation is identified, not just a notice, but also a fine and a judgment could be coming immediately afterwards.
Thank you. And Lucas, do we want to spend another minute on user-enabled global privacy control signal, just to make sure that everyone understands what that entails?
Yeah, we absolutely can. So as Michael mentioned, these 4 different pieces are the specific failures cited in the judgment against Sephora that came out a few weeks ago. So these are the things that were specifically focused on by the California Attorney General. And one of the things that was mentioned multiple times, including in press afterwards, was this focus on global opt-out signals and respecting them. So the global privacy control is one means of a user providing this global opt-out signal. And what that would be is a signal or an indication at the browser level or at the device level that says, I want to opt out of everything. And that needs to be respected by your architecture. So, you can transfer this personal information. You can sell personal information of users. It's so long as you're disclosing it and so long as proper protections are in place until that point when the user expresses their opt-out indication. Most people think of that in terms of the California law as that do not sell my personal information button that is required to be on the homepage as well as any page on which personal information is collected. But in addition to that, any of these global opt-out signals, like again, global privacy control as one example, also must be respected. So that's a big component of California's, where they've signaled that enforcement is going to be focused moving forward.
And now let's dive into things to consider.
Yes. So we talked about what the violations were, which all centered around not properly disclosing that information, that personal information was being sold, and then not providing users the ability to opt out, and then not respecting opt-out signals once they were actually raised. So what is it that we can learn from this? And what is it that we can really consider and think about as we're thinking about preparing our own digital properties for preparedness now, and especially for January 1. And the first piece, and it's not listed on here, so I guess easy to omit, is you need to map out all of the data collection that's happening, the platforms that it's going to, and understand what personal information is being collected, one. Two, what bits of personal information are being sent to third parties or transferred to third parties versus service providers or some of the other definitions in there where sale has some exemptions. And then which of those activities constitute the sale of personal information, or again, come January 1 with the CPRA updates, sharing for purposes of behavioral, cross-context behavioral advertising. It's super important to be able to map that out first so that you can then take these steps and follow these obligations when you are in fact selling any of that personal information. The first thing to really focus on is one, disclosure. You have to disclose in the privacy notice the fact that personal information is being sold. We talked about how broad that definition is. So I can almost guarantee you that all of you are selling personal information in some capacity. As a part of that disclosure, also need to include the categories of personal information sold, to whom that information is being sold or shared with, again, what third parties, where is it being transferred, and then also users' rights with respect to that information. So the fact that they can request it, they can request that it's deleted, they can opt out, those types of rights. All of that needs to be disclosed to users. And obviously, you can, I think, understand why that mapping activity is so important up front. Now, once all of that information is disclosed to a user, they then need to have the ability to opt out. Now, again, there are two different ways that a user could express that opt-out desire. The first one is that do not sell my personal information button, which unfortunately, I know marketing hates it, but that is the terminology and the text that has to be used as outlined in the law. That needs to be located on the home page or the landing page, as well as any page where personal information is collected. So essentially, it's a fancy way of saying all pages of your website that a user would access. Also, you need to respect users' opt-out signals via any kind of global opt-out mechanism, specifically cited again and again by the California authorities, is the global privacy control mechanism. That mechanism is being built into browsers. So Firefox, Brave, DuckDuckGo, several other privacy-focused browsers already have support built in, as well as that signal is built into a number of plugins, ad block plugins, as well as privacy-focused plugins that users could download for really any browser. So it's possible, becoming probable, that you have visitors visiting your website that are signaling using global privacy control, that opt-out signal. That needs to be listened for and respected with your opt-out architecture, either blocking tags from loading or restricting data processing to be able to limit that sale processing activity by each platform. Cool. So those are the obligations when selling. The next piece here that we wanted to introduce is just a live example. I want to walk through an example so that you can see just for any website. And I encourage you, if someone wants to throw in any website they want, throw it into the chat so that I can see that, and we will go to it. And we'll just walk through these steps of what's for this enforcement sweep, kind of some of the details that we can glean from what the California AG in this case is looking at. And we can just do a quick evaluation of, is the website that we are providing, is it following these various different requirements? One, are they selling information? If so, is that reflected in our things like global opt-out signals being respected? So let's see. So yes, anyone, feel free to throw in a domain in the chat. This is not a trick, a trick question. Okay,
there is a newbalance.com website that's already submitted.
We do have one here. Okay, newbalance.com. One quick note, because we are simulating this for CCPA, which is something that protects California residents, I am using a VPN, so it is as if I'm accessing the website from California. So any kind of like conditional setups that are on the website should be being respected. So first thing here, just so that I can display this for the global privacy control, I am using a plugin in order to signal that GPC signal that I would want to opt out. So for the New Balance website, first, let's see, is an activity happening that would likely fall under that sale definition? And if we look on here, platforms like Criteo used for retargeting, likely that is audience creation. You are then targeting those users via that platform. That would be transferring data and likely falling under that sale definition. Same thing for some of these Google ads, for sure, Google ads, remarketing platform. And even for GA, you can tell here, and I can tell that advertising features are enabled within GA because the presence of this double-click hit, which is a redirect hit, that happens when advertising features are enabled within GA. When that is the case, GA restricted data processing is not applied. That would fall under the sale definition. So yes, that is happening here. So we can say that likely that sale definition is being met with this website, which then means we need to think about our obligations. So first one being here is that do not sell my personal information. Is that button available to me? And I do see that it is available here within the footer. I can also check just for within the privacy policy here, if that sale information is being disclosed. We won't get into the nitty-gritty kind of specifics here, but some of these different activities are listed. It does seem that my rights are disclosed to me. So at least I'm being told that yes, I can opt out, and that yes, personal information is being sold, shared here. So then it comes to that second obligation of, are my like opt-out wishes being reflected? First one being, as I mentioned, I am using a plugin, so my GPC signal is on. So if I refresh this page, do I see any changes in terms of the behavior for the tags, the data that's being collected? Is the sale activity being stopped as a result of that GPC signal being active? And it doesn't really look like it in terms of, there's no difference in the platforms that are loading. There's no difference in the data that's being collected, as well as the number of just the tools that are being used. No differences there in terms of the architecture. So it looks as though that the GPC signal or my global opt-out is not being respected. I can then test and look, if I do click on that do not sell my personal information, if I do opt out of this, of these things, and I'll just go through and should be able to do so in general, blanketly, but I will just manually do it and then confirm my choices. If I then reflect or refresh, now that I have explicitly provided those opt-out signals, does that behavior change? In a few cases, it looks like it does. I would question, enabling the restricted data processing for Google Analytics specifically, because this would still constitute a sale, even though I have opted out, as well as some of the other advertising platforms here. Potentially either A, blocking them from loading, or B, there are mechanisms within each that you could configure in order to restrict that processing, make those different providers a service provider as opposed to a third party, and still meet some of those different requirements. So those are some of the things that you can look at. And we do also, for everyone for joining the webinar today, thank you very much for providing that New Balance example as a live example, so we could walk through each of those components. But if we want to, you can submit, we'll share this link here, and our team will actually walk through, look at these exact same things. Are there activities that are likely constituting a sale, especially as clarified with this most recent judgment? And then are those obligations of disclosure, specifically disclosure and respecting of opt-out controls, are they being followed? So that link is now in the chat. So feel free to check that out, submit a website, submit your information, and we can follow up with that information.
Lucas, and we have one question. If you didn't want to recognize a browser GPC signal, could a cookie banner be used to respect the opt-out of sale choice?
Both need to be. You always need to respect the browser GPC signal. That's been very, very explicit with within the draft regulations associated with the CPRA that the California Privacy Protection Agency is working on, and it should be published soon. But very explicit in there, as well as very explicit in the California Attorney General's comments following the judgments a few weeks ago, that the GPC, that's really a cornerstone of what they're focusing on as it relates to those opt-out signals.
Thank you.
It's more user friendly at the end of the day, I think is where they come from.
And once again, if you would like us to review your website in similar fashion as we just did with newbalance.com, please click on a landing page, and you can see Chase posted a link in chat, and we can take a look. We can summarize our findings, and on a call walk you through what we've discovered and the actions that you might want to consider taking. And we are right on time. Thank you everyone for joining.
Thank you all.